So hi everyone and welcome to this month's Facebook Live from the Art of Estate Planning. It is the 8th of August 2024. I cannot believe we're in August, but what an exciting year it's been. My name is Carrie Payne, presenting on behalf of Tara Lucke. We are really excited about this topic, so much so that we've divided it into two. So we're talking about insolvent estates, but we've separated out into a two-part series. The first part is available on our Facebook group, and also for those that have portal access through the portal if you want to listen to that. And today we've got Kevin Finn joining us to talk about the second half of that discussion. So I'll talk about Kevin in a moment, but just a reminder that this is a forum where you are able to ask questions. So if you type in the comments, let me know, number one, that you can hear me where you're dialing in from, so I make sure that the technology is working. But also, if you've got questions and you want to ask them, put them in the comments. We'll try and raise them at logical intervals for Kevin. If at any time it's a question that I think we need to take offline or needs a bit more discussion, Kevin's going to provide us his details. He is in the group as well, so you can reach out to him to discuss any parts of the presentation. So while we're talking about Kevin's pretty fantastic, and usually I do a discussion about our presenters, but Kevin's kind of stolen my thunder, and he's got a whole slide to talk about how great he is, so I won't steal that from him. But certainly he's got a lot of experience, and we're very thankful that Kevin can join and share his knowledge with us today. So Kevin, without further ado, as they say, I'll let you take the floor, and looking forward to hearing what's going to happen.
Thank you. I've just got a PowerPoint presentation here just to sort of guide us through the discussion, but I'm more than welcome for people to ask questions as we go. I do like the sessions to be interactive when I'm doing a presentation. So just a normal disclaimer, and I'll probably preface this in terms of insolvent estates can be quite complex, and you do often need to look at getting other advice, particularly accountants, maybe insolvency practitioners, to help you manage through the particular circumstances, particularly if it's a more complex matter. Just a quick bit about me. I'm a consulting principal with Key Point Law, lecturer at the College of Law, and accredited specialist in wills and estates. So just overall, firstly, why would you act in an insolvent estate? Determining who your client is, initial steps, collecting of assets, dealing with creditors, exempt assets, costs, and final distribution. So the first question is, why would you want to act for a client in an insolvent estate? And generally, my rule would be to avoid acting if at all possible. So if a client comes to you, there's minimal assets, there's a bucket load of liabilities, and there's no related entities and no other assets likely to come into the estate, such as super or life insurance, I'd pretty much be saying to the client, just get out. Just don't intermeddle, don't touch it. Let the creditors sort it out. If the client's happy with that. However, there are circumstances that you may need to become involved. For example, if a spouse or family member is being harassed by creditors, you may need to write to those creditors and say, nothing to see here, and go away, or you can take out the grant yourself. And that also comes into who your client is and what capacity you're acting in. So that instance, you might be acting for them as an individual as opposed to an executor or administrator if there's no will. You may need to look at acting in an insolvent estate if there's related trusts where the legal personal representative has a power of appointment or other roles under the trust deed, where the deceased owns shares in a corporate trustee. If superannuation must come to the estate, you may need to look at that. Or there's related family trust loan accounts and the client wants to retain a level of control. And that particularly may look at resolving how to get out of, minimise the impact of the estate, so a business that's run in a related family trust is able to continue running. The number one thing when you're looking at an insolvent estate, and look, any estate, is who is your client. It's very critical to ascertain that at the outset and what capacity you are advising them in. And that's particularly important where a client has multiple roles. So a client may be the appointed executor, they may be a beneficiary, they may be a shareholder or director of a related entity, a trustee of a related family trust, or a trustee or director of a corporate trustee of a related SMSF. The ethical considerations. The golden rule, particularly with insolvent estates and anything ethical, is who is your client. Those of you who are on the Facebook group who have ever seen someone comment that they act for the estate and have then seen me respond quite vigorously, you never act for the estate. You're always acting for the executor administrator of the estate. And that's critically important to think of that when you're managing a lot of the ethical issues, is who's your client, who's providing you instructions. When I do lecturing, I threaten students if they ever write they act for the estate, that it will be an automatic fail. I've never actually had someone that's then gone on to write that, but I can't stress enough. You may need to consider from a firm perspective whether you've got a conflict of interest if you've acted for related entities, particularly if there's loan accounts that there might be some contentious issues around. Not necessarily that you'd be conflicted out from acting, but it's just something you need to continually monitor and manage. And often you might be having a client that's the executor, they're a trustee of a corporate entity. You can possibly manage those conflicts of interest efficiently. And I say that often the client's got the conflict of interest, not necessarily you as the practitioner. So you may need to stick, okay, I'm advising you in your capacity as executor of the estate. And in that you can entwine, and always thinking of entwining your advice around their role as executor and say, well, in this capacity, the family trust may have a argument that the debt's not due to the estate because there's a statute of limitation problem. So you can just think about how you're crafting that advice. You're essentially giving the advice, but in their capacity as executor. And usually when you're looking at an insolvent estate, you're acting for the named executor or the person entitled to apply under intestacy.
Kevin, I might just jump in there. I think that's, you said a couple of really important points here. Knowing when not to act is a really smart choice. I think we do feel like sometimes like we need to do things and we need to help people. A bit of that compassion fatigue kicks in. But certainly knowing when to say no, it's not your wheelhouse, so to speak. Just for the purposes of those that are listening in, when we talk about potential conflicts of an insolvent estate, obviously, the conflicting parties would be your creditors. That would be beneficiaries as well of the estate too?
Would depend what the beneficiary's entitlements end up being. So if there's insufficient assets to satisfy creditors, the beneficiaries aren't going to have an interest. If it's borderline, you may have a conflict there with beneficiaries. Often your client is a beneficiary as well, so their interests may be aligned with the beneficiary in any event.
Yes. Is there anyone else that we should be thinking about, as a potential conflict?
Well, obviously, if you're acting for creditors concurrently, then there's a potential conflict there, because obviously, from your executor point of view, you've got an interest in getting the liabilities as low as possible. If you're considering whether you put the estate under the Bankruptcy Act or administering under the state laws, obviously under the Bankruptcy Act there's clawback provisions, so there's considerations there that may conflict you with existing clients.
Yeah.
And similarly with those related entities, if you've acted for the deceased, in their role as a company, as a director of a company or for a related company, you may have a conflict there.
Yeah. Thanks, Kevin.
It's not necessarily saying that there is a conflict. It's just identifying that there may be a conflict, and if there is a conflict, if there is a potential conflict, looking at the degree of it, calling your ethics hotline if you want, or talking to other practitioners.
If you've acted for a trustee in bankruptcy, so I know there are practitioners out there that do act as trustee for bankrupt people in estates, is it a conflict if you they're against you, so to speak, on another matter, or?
I haven't thought about that.
Just throwing the rock in there, Kevin.
Yeah, I think it would be more so if they were the trustee for this particular estate.
Yeah.
Again, I know in Victoria, if you've got those ethical issues, it's quick call to the ethics hotline. So imagine other states have similar, but it's also just consulting other practitioners in the area and say, I've got this situation, what do you think? And I sometimes find that having a conversation with another practitioner in this area can be beneficial to help you in a discussion with ethics.
Yeah, I know certainly in Queensland we have the Queensland Law Society's ethics team, which you can, my experience with them has always been fantastic for the comments that they give. So I'm sure that's something that's available in other states as well.
Yep. And Carrie, just picking up on that point about, you mentioned about when not to act. I probably should be a little bit more clear on that. It's not necessarily when not to act, but it's when advising your client not to act as well as an executor. So they're not obliged, obviously, to take on that role as executor or administrator. So if there's creditors chasing $100 that's in the bank account, it's giving the advice to the executor, look, you're under no obligation. I said, I know it's stressful to have these creditors. How about you engage me as an individual to write to all these creditors and say that there's nothing to see here? And then it sort of steps out to say, well, your client's not prepared to act as an executor. The assets are insufficient to make creditors. Your client's not intending to administer the estate, and it's up to them. And it may mean that there's money sitting in the bank account that ends up with unclaimed monies, but there's no point your client doing the work, engaging a solicitor when there's insufficient assets. Obviously, your fees get paid first, along with the funeral expenses. And sometimes you might embark on that course, but it's not worth the stress for you or your client, I find.
Yeah, that's totally valid. Yeah, I think making sure that people know that they're not in for an easy ride, and yeah, I think even as people, you feel that you have to step in and help out, but I think sometimes that there's not. Yes, it's not an easy situation to be in. So knowing that they can walk away is big.
Yeah, and really important. First up, tell them not to pay any liabilities. I remember I picked up a mess to clean up where the spouse had been paying all this guy's debts, and there just wasn't assets to cover it. She shouldn't have been paying them. So it was, we then tried to claw back what they weren't entitled to. I didn't end up finishing off that file. I moved on before that was finished off, but that was a real mess to sort out, because there just wasn't the assets available.
Mm. Thanks, Kevin.
Okay, so look, initial steps, it's like going through that process of identifying assets, identifying liabilities of the estate, where you can, advertising notice to creditors. So in Victoria, we've got the Trustee Act that allows you to advertise for creditors. Normally you do that after the grant of probate. It's in assessing the position of the estate. Do you want to put it, send it off to a trustee in bankruptcy? You have the estate bankrupt. And when do you want to time such application? Do you want to make the grant and then put it into under the bankruptcy provision? Do you just want to put it bankrupt first and then apply for a grant for any exempt assets? There's a couple of considerations there, and each case will be specific to itself. Or do you just want to administer it without going under the bankruptcy provisions? And that can be an attractive option for creditors, because obviously if you go through the bankruptcy provisions, there's a lot of expense that can be involved, whereas you administer it informally, they may get a better cents in the dollar return. Grant of representation. Again, coming back to the question, consider if the estate needs to be put into bankruptcy, and you may want to engage an insolvency practitioner to help you with those decisions, particularly if there's related entities. So if there's related entities, an insolvency practitioner, there might be related issues with those other entities. You may have a business you want to keep as a going concern. So the insolvency practitioners can be of assistance in terms of negotiating payouts to creditors on a cents in the dollar basis. And also the frequency that we're doing these on the deceased estate side, having that little bit of expertise from that insolvency practitioner can be beneficial. Consider whether the grant's required, for example, exempt assets, super and life insurance. And generally, if you're going to go bankruptcy, you want to do that before the super and life insurance come into the estate. If the LPR is a appointor under a trust or a related entity, you may want to get a grant. My general view is if you've got a deed where the successor appointer is a legal personal representative, you should get a grant. So it's crystal clear that the appointed executor has the power to replace the trustee or exercise the powers under the trust deed. Again, it comes back to read the trust deed. And then also shareholdings of private companies. If you do go under bankruptcy, those shares would vest in a trustee in bankruptcy. So you may want to get in to become a director of those companies in the intervening period. You've also got some considerations there with corporate trustees. Obviously, they're just a nominal shareholding. You may need to consider whether you are replacing a corporate trustee so that those shares don't flow through to a trustee in bankruptcy. I've discussed about... Yep.
Sorry, Kevin, I just thought it might be a really good point to make. Obviously this is an estate planning group.
Yeah.
One of the considerations potentially where the estate itself might not, might be insolvent, but there are assets inside other structures. I mean, number one, looking obviously at your financials for your trusts and seeing if there's any UPEs owed out to the deceased is really, really big. But from a planning perspective too, sometimes we do rely on these default succession mechanisms for it to go to the LPR of the person. And one of the considerations you might make, and jump in if I'm wrong, is to do a deed of successor, even just to appoint that person to sidestep the need for it to go through that process. So, you might circumvent having to get the grant to prove you're the LPR, and therefore it just takes it outside of that estate phase.
Yeah, definitely. That's an important consideration, is looking at a separate deed of succession. And I generally, most of the time, to date I've been doing it under the will, but I'm considering more and more whether I should be doing a separate deed of succession in relation to the trusts, and then looking at adjustment provisions in the will. But obviously that's fact specific. But obviously, if control of a specific entity is to pass to a particular person, then a separate deed of succession's generally more ideal. But you've still got that issue of the shareholdings in those corporate trustees. You may need to consider additional shareholdings or joint shareholdings, again, coming back to each specific circumstance.
Yeah, I suppose if our focus is obviously if there's an appointer or principal power, you can always boot that trustee out. So, I think it's just something that, when we see, there's a default succession mechanism, it's the LPR tick done. But, where there are issues around how the estate itself is going to go, whether it be from an insolvency or an estate challenge perspective, and that role itself can be complex, whether it's worth thinking about that to circumvent these issues.
I'm leaning more and more to doing the separate deed of succession for entities in the planning piece now, but I haven't sort of come to a final view on that.
Yeah, sorry, I thought let you keep going, Kevin. Just thought it was
no. That's all right. That's all right. I think I'm running a bit ahead of where I was planning to be, so I'm more than happy for more questions to come in. Coming into the collecting in of assets, and if you've got an insolvent estate, you've got potentially more pressures on you as an executor or an administrator if you're going down that informal path. Look, secured creditors, if you've got a property that's got a mortgage on it, you need to consider, or do you let the mortgagee take possession and sell the property, or do you liaise with the mortgagee and say, I'll take control of the sale of the asset, and that can help from a cost perspective, and then try and maximise the proceeds of the sale of that property for the benefit of obviously creditors, which may be more relevant if you've got those liabilities owing to related entities. Also, you need to be looking at validity of unpaid present entitlements and loans, looking at statute of limitations, whether there's interest payable on those unpaid present entitlements or loans. Generally, if there's no agreement as to interest, you're sort of stuck with that capital. And you usually find with dealing with creditors that they won't be charging interest after date of death. Secured creditors are usually a bit different. They've got that. They'll usually keep accruing interest, as most people in the group would be aware. When it comes to the sale of assets, it's really, really important to be engaging professionals and advisors to help that, and particularly so to protect your clients. With real estate, it's getting a sworn valuation, not selling for less than the sworn valuation. Looking at engaging a vendor's advocate to help you with the selection of a real estate agent, and maximising the sale price. I probably shouldn't say this joke in a recorded session, but I will anyway. But the old joke of how do you know when a real estate agent's lying? It's when their lips are moving. So I find the
pretty sure, Kevin, that's the joke about lawyers, right? Like, not to defend real estate agents, but I'm pretty sure the joke applies. I'm pretty sure I've heard that joke apply to lawyers. So
yeah, real estate and politicians are the usual culprits for that particular joke. Yeah. So I can't do a presentation without adding in some humour. So yeah, but the vendors advocates I find are useful because they will help you keep the agent to account. So holding them to account to help maximise the sale price for the estate, and also assisting with making those decisions around do you furnish the property for sale? How do we advertise it? Is it expression of interest? Are there any unique aspects around the property? And also with other assets, such as vehicles, making sure you try and sell it independently. Don't go selling it to a relative. Keep it all arm's length. You know, take it to 3 car yards. What are they going to offer you? Get it in writing. Because you don't want the creditors coming back at a later stage and saying, well, you've disregarded those assets. If there's chattels, getting there's companies out there that will help with clearing out a property, and you're getting the most value for the chattels, or even getting someone to clear out the property as a starting point. I've recently acted on as administrator of an estate, where the property had to be cleared out. It did cost. It ended up costing the estate money to get that person in. They went in. They sold what they could. A lot of it was scrap metal. They sold what they could. They finished clearing out the property. It wasn't a cheap exercise, but as an administrator, I can turn around and say, well, I got someone experienced in knowing what they do in terms of identifying where assets could be sold or disposed of, and also to clear out the property, because that property took 10 days of labour to clear out. So as an administrator, I don't want to do that. And a lot of family members may not want to do that either.
Kevin, having just done it for my own family, 10 days is conservative. So, that's, it depends on how long they've been in the house, whether they collected everything known to man like my own family member did. 10 days is pretty conservative, the physical and emotional labour of doing it.
Yeah, and these were professionals. These guys know what they were doing, and there's no emotion with it. It's all commercial. I can't speak more highly of that. And I, in fact, referred this a colleague of mine. Her parents are needing to declutter, and I put them onto him as well, because he obviously knows where art can be sold and those sort of things. So engaging advisors or people that have a bit more experience is very useful. And remembering your costs associated in a deceased estate are testamentary expenses, so they are paid before, obviously, if there's sufficient assets. Dealing with creditors, and the first point is the most important. Communication's key. And particularly if you're seeking to avoid bankruptcy or things becoming complex, is keeping the creditors up to date. Advertise for creditors. So, as I said, in Victoria, we've got the Trustee Act, and there's similar provisions in other jurisdictions. You may wish to consider whether you want to advertise for creditors in other states as well, just to make sure you capture all creditors, particularly if you're administrating under state law as opposed to Bankruptcy Act. There's also a very important ethical consideration when communicating with creditors, and that is to not misrepresent the estate. And this matter I told you about, referred to before, where I was cleaning up someone else's mistakes. They wrote to all the creditors and said there is no cash to pay creditors. When you actually looked at the true position of the estate, there are unpaid present entitlements from family trusts. So that, in my view, I don't think it was intentional on the part of the practitioner, but care does need to be taken, because the creditors often don't forgive the debt. They'll leave it sit there. They just won't pursue it. And you often get letters back saying, well, we're not going to pursue this at the moment, but if further assets are identified in the future, please come back to us, or you should come back to us. So taking an approach, you should write to those creditors and be upfront. Initial inquiries indicate that the estate is insolvent, and that you're currently ascertaining the assets and liabilities of the estate. You can go further than that and say your client's intending to administer it under as an insolvent estate and not put it into bankruptcy. You could say you believe that you'll get a better return for the creditors from that point of view, and keeping them informed throughout that process. And you also probably need to consider, in terms of that, is if you did administer under bankruptcy, whether the clawback would actually be better for creditors. So you've got a bit of a thin line there in terms of balancing how you manage that. Once your assets and liabilities are known, be fully forthcoming with those creditors as well. And let them know what how you're proposing to deal with it. Exempt assets, superannuation and life insurance. So I think in the first part, Natalie covered off that they're exempt assets from the bankruptcy. But if they do come into the estate, they may be available to creditors under bankruptcy provisions. So you've got some careful considerations there around, do you put the estate into bankruptcy before those assets form part of the estate? Because if you put the super and life insurance come in, then you put it into bankruptcy, those assets could be available to creditors. So that timing, that identifying what may come into the estate is critical as well. Obviously, if you've got self-managed super, you've got a lot more control. But if it's retail super or industry super, you can be at the mercy of the trustee's discretion as to where they pay it to. Often you'll find if they are intending it to pay it to the estate, if you let them know that the estate's insolvent, they may consider paying it to somewhere else. But you're going to be subject to the terms of the super fund trust deed. And life insurance, you can be often stuck with who the policy owner is. Costs. Oh, sorry. The correct presentation hasn't uploaded.
That's fine. I'll let you just start to work that out, Kevin. I think that's interesting about the life insurance and the superannuation. So we have actually, you probably know, we have our TT Precedents Club, which is a membership group from the Art of Estate Planning with Tara, and we have discussed about that position in regards to life insurance. And so I find it interesting, that concept of, if it does come into the estate, it might potentially still be. So, that was something I think the last presenter also sort of touched on very briefly. Is that position changed if the life insurance was for a specific purpose and did have beneficiaries named on it?
If you, if the life insurance got named beneficiary, it's going under the terms of the policy.
Yeah.
So it's really looking at if I got one of these complex matters, it's getting the insolvency practitioner involved at the early stage, and getting their advice, because they should be able to help you through all of those issues.
We've got someone here asking, Denise is asking, super binding death nomination not to estate also. So that is obviously a strategy that you can adopt as a part of your planning stage to direct superannuation funds away from an estate.
That's obviously one of those, you're directing it away from the estate, but often you want to have it come into the estate anyway. So you may be looking at, it's coming to the estate, so just put the estate into bankruptcy before the trustee has made the determination to pay it out to the estate.
And so that act of putting the estate into bankruptcy then preserves the life insurance?
potentially, because this life insurance hasn't come to the estate at that time.
Okay.
You may need to end up getting specific advice on it, or directions from the court. Obviously, it's going to depend on how hard your creditors want to go as well.
Yeah, it seems an unfair sort of position when you might not even know that an estate is insolvent, and so you do what you think is right. So it sounds like an unfair outcome given what life insurance is for. But I suppose
and same with superannuation, because ultimately super's there for the benefit of the member or their beneficiaries in case
their dependents. That's their that's the whole position of what super is about, for dependents.
Yeah. Just try and get this presentation back up.
Yeah, I think there's a lot of comments just while you're doing that, Kevin. There's a lot of comments, Tara and Laura and I talking about, that whole process of basically packing up a deceased estate house. And again, having just done it with my own family, it is an incredibly exhausting process. But, if and that's what I am too. I am going to be the administrator of my father's estate. How do you value stuff? Stuff that's ostensibly valueless to most people, because, it might have a buyer that might buy it at this dollar value, but if you don't have a buyer, it's not really worth anything. So it's this. We were cleaning out my father's shed, and there was this rowing machine that I hadn't seen come out of that position in the house for 32 years, because we put it in there when we moved there in the 90s. And so, bring it out again, it's just scrap metal to us. But, that whole process is very interesting. So
and if you look at a lot of the times chattels, they just, you're not going to get anything for them. Like you go to IKEA and you buy a bookshelf. You go to sell it a year later on Facebook, and often you're just needing to give it away.
That's right.
Because people don't want it, or they're happy to go to IKEA to buy it flat packed, rather than have to go disassemble it, pack it in their car, or hire a trailer. And you're trying to sell antiques can be difficult as well. Not many people are interested in antiques anymore. So that's why often it's just as good just to go get someone in. It's also the cost of doing it. Like if you've got a house full of furniture, how much time do you want to spend putting it up on Facebook to try and get a seller for it, and then haggling over prices? As an executor, your time's often more valuable than that. So get someone in to do it.
Yeah. Sounds great in theory, doesn't it?
Particularly acting as a professional, you often want to just minimize. You want to outsource as much of that as possible, because if I go and $500 an hour to clear out a property, that's not economical for the estate, and I don't have the expertise to do it. And this particular estate, there was about 4 gas bottles in the property. There was oxygen was one of them. I can't remember what the others were, but they needed specialist removal skills. So I would have to be like, if I was to be managing all of that myself, it's like, well, who do I go to for that? Do I need to go and get 3 quotes? Whereas the people that I've got, they've got their people that they know are the right people for the job. They know what their rates are. They know what's cost effective. They can just get on and get it done.
So. We've got someone here as well asking, could you delay notifying the super and insurance providers so they don't release the super and insurance until you've put the estate into bankruptcy?
Well, you could make those inquiries, but obviously they're always requiring that further information prior to releasing the funds.
Yeah. A lot of people.
There's a bit of a grey area as well, because with the life insurance, is that a when does the interest arise in the deceased estate? Is it on death, when the life insurance arguably then becomes payable to the estate, or is it when it's actually paid into the estate?
Mm.
So there's a
And
few
even
issues.
someone's put a really valid comment here, Taylor, saying, what are your thoughts on the duty of the executor to maximise the value of the estate? Example, claiming super into the estate when the executor knows those funds would be used to pay debts, which is not in the interests of the other potential super beneficiaries.
So in terms of it coming to the estate as opposed to going directly to the beneficiaries?
I think she's sort of saying that, if your duty as an executor is to maximise the estate, should you technically be putting the estate into bankruptcy first before it's paid? Like, is that your duty to do that so that those proceeds are protected, rather than, chucking them in the estate and then determining that then we need to put things into bankruptcy because those assets.
It's an arguable case. It would probably be fact dependent. I think if you were aware of the bankruptcy, I think your prudent approach would be to put the estate into bankruptcy before the super comes in. If the super came in and then you found out of the bankruptcy, I think you'd be excused as executor for that. I think if your super came in, you'd be trying to negotiate with creditors that just not be counted and administer it without going under bankruptcy. So if you end up with that situation where something comes in that could be available to creditors, I think you'd be trying to do a deed of arrangement with the creditors. And say, well, this super, I try and argue it's an exempt asset, and push it through that way.
Yeah. It's you're very right. I mean, it's such a horrible lawyer's answer to say, but it really does depend. It depends.
So
I think
the insolvent estates, once you've got super and life insurance, they're not easy. There's a lot to consider. And it gets even more complex if you've got the related entities.
Yeah. Thanks, Kevin. Sorry to interrupt you there
and
take you on a tangent.
No, it's good. It's padding it out a little bit, which is good. Now, costs. So obviously, as an executor, your costs are covered as a testamentary expense. But there are some questions around exempt assets and non-exempt assets. My view, and there's a case, and I can't recall what it is. I'll try and send it around, add it into the comment attached to this later. There was a case that dealt with this issue around costs in a little bit of a different circumstance. In this particular case, the trustee in bankruptcy collected in the super because the named executor didn't apply for a grant of probate, and they kept I think the deceased went bankrupt before date of death, and then the executor didn't apply for a grant, so the trustee in bankruptcy collected in the superannuation, and then there was an argument around, well, where does the trustee's costs associated with collecting in those exempt assets lie? So there's the case on that, but essentially from it, my practice would be to have a file running for your non-exempt assets and a separate file for your exempt assets, and for your exempt assets to go into on a separate trust ledger if you're managing funds through the trust account. I think keeping that distinction around costs is very important. And again, if you're then negotiating with creditors and you're doing the full and frank disclosure and there's super there, you can clearly say to them, those costs are being charged against the super proceeds, as opposed to against dealing with the other creditors. Or trying to do it on a cents per dollar, because often your superannuation will be sufficient to pay out your creditors. Distributions. consider a deed with creditors, particularly to release your client as executor or administrator. Disclosing all the assets, disclosing all the liabilities, what the cents in the dollar return to creditors will be, and getting them to sign off on that. And particularly if you've got those related entities as well. So if you've got a business in a related entity, there's a unpaid present entitlement to the estate, you may need to do some negotiations with your creditors to buy out their debt or similar. So you're not having to wind up a business declaring your unpaid present entitlement. That's really...
With the deed that you make with the creditors, is that something that, because I know you said before that, that they will just not chase the rest of the debt. Can that deed say they're not going to chase the rest of the debt?
You can try and negotiate.
Yeah.
And you will want to do that anyway. And again, it's the full disclosure thing. To say you've done all the inquiries, you're not aware of any other assets of the estate. These are the liabilities, and this is the proposed payout. The other thing, don't forget executors' commission, because this isn't an easy process for your client. So you may want to throw into the mix executors' commission for dealing with all the pain and trouble of having to go through this process, having to instruct solicitors, take advice. It's not an easy process for a lay person. As a solicitor, it's not too bad. It's part and parcel of what we do. But for a lay client, it can be stressful because they're getting letters from creditors. What do we do with this? What do we do with that? They've got that uncertainty because they don't know how it's going to go. I always say to my clients, I'm not stressed about it, and if I'm not stressed, you don't have to be stressed. But the clients will often stress, so don't forget your executor's commission to try and get some benefit for your client. Sometimes you might want to get the beneficiaries to sign off as well, or the named beneficiaries under the will. Probably one thing I haven't mentioned in this presentation is keeping them up to date as well, because obviously they may have had someone close to them die, expecting that they're going to get a benefit under the will. So keeping them informed. I don't think it's necessary for them to sign off a deed unless they're affected by it. So if you've got super or life insurance that's going to them, you may want them to sign off on that as well. Particularly for apportioning costs to the super or life insurance. So coming to the end, so summary again, considering whether to act or advising your client to act as executor or administrator, the capacity your client is instructing, identifying the assets and liabilities, care with dealing with creditors, segregating exempt assets, costs, and then the final distribution. Any questions?
I think we've had most of the people asking questions in the chat panel so far. So if there's any questions that you have that might turn on facts, please feel free to reach out to Kevin. Kevin, as I said, is working at Keypoint Law, so you can reach out to him and have a discussion there. What I think, Kevin, is really interesting is, I think, because, again, we are an estate planning group, so that dealing with those related entities, the insurance and the super, and how we manage those from a planning perspective is so critical, because, I think obviously if we're on notice about the client potentially having an insolvent estate as a planner, that makes it absolutely clear that we do have to very carefully consider those. But also, clients aren't always going to come forward and say to you, I'm bankrupt, or I'm this, or I'm that, you know. So it you know, if we're always relying on clients to tell the truth, I think that's a very bad position to start from. So
yeah,
you know, and making sure too that our when we send things to clients, it always is in the context that this is based on the information you having told us is actually correct. So
yeah, and also on that planning piece, it is getting those financials in, and yeah, one of the things that I don't know why accountants do it, but you know, there'll be a husband and wife, and they'll lump the unpaid present entitlements in the accounts together and treat it as a joint thing. And then when one member of the couple passes away, they just do it via survivorship. And to me, that's not the correct way to do it. And yeah, can present those issues, because yeah, when the distribution's done, it's done to the individuals generally. Yeah, well, I probably you could do it as a joint and several, but you want to be pretty clear in your minutes of distribution that it was done on a joint and several basis, or that the UPE was there on a joint or several basis, or not have the UPE in the first place, which is ideal. Pay it out and recontribute it as capital, and have the transactions to show it.
Yeah.
Is generally.
I think UPEs are a very big sleeper issue, you know, in estate planning generally, let alone when you're dealing with insolvent estates.
And particularly with couples. So if you've got we put asset protection into place. So if you've got the I'll go gender specific, but if the husband's carrying the risk and there's no assets in his name, and you've got an unpaid present entitlement to him with the family trust, that's where I see these issues with insolvent estates come up. Is husband might have personal liabilities or a 20 grand credit card, and then there's a UPE sitting over in the finances.
Yeah, yeah. And just to clarify too, Denise is making a very valid point, is obviously in the comments that, you know, we might do everything according to today's date, but then the financial difficulty might arise after we've drafted those documents. So,
you
know, we can do everything we can to our best abilities and knowledge at the time, but it reinforces that, yes, you can't plan for everything, and also the importance of revisiting your estate plan when big things happen, like financial difficulties. So
yeah.
I think that's all the questions we've got. So as I said, if you've got any questions that you want to take offline with Kevin, feel free to reach out. Kevin, are you comfortable sharing the slides for those that wanted to, so they can get in contact with you? Yep. So we'll put the slides up and the recording up as per usual. As I said, Kevin's in the group as well, so he'll be there correcting us about the correct name of the legal entity we're acting for. I love that kind of.
It's one of my things. It makes my blood boil if someone writes to me and says, we act for the estate. And it's an easy trap to fall into. And admittedly, I was in a mediation 2 weeks ago and made the mistake of saying that I acted for the estate, and I kicked myself immediately. And then the barrister followed suit and said that he's the barrister for the estate. So I nearly.
It's like saying that you act for a trust. You don't act for the trust. You act for the trustee of the documentary.
And it came back when I had called the ethics line and got the same person who I've known since I was very young, and his first question to me for a while was, "Who's your client?" And then when I sort of thought that through, I was able to answer the ethics issue myself. And so now I call him and I will start saying, "I act for X as the executor of."
I look forward to that sort of pedantism in the comments, Kevin. I really do.
Look, and I jump on it because it's so critical in this area to think of who your client is, and I've seen practitioners fall into that trap, and they've ended up in an awful mess because they've gone along with the thinking we act for the estate, and yet particularly if there's conflicts between executors, it becomes you've got to think who your client is and do I have a conflict because my clients aren't getting along, and not thinking I act for the estate and I've got to do this, because you've got to give advice to both executors.
Yeah. So thank you so much again, Kevin, for your time today. I really appreciate it. Hopefully everyone got some good little practical points out of that presentation, and we're looking forward to hearing more of you, Kevin, and what you're going through with Key Point Law. So
Thank you.
Thanks again, everybody, and have a great day.
Great. Thank you very much.